Next case on our calendar this morning, it's Kalorama Citizens Association et al. Versus Suntrust Bank Company et al. Good morning to you, counsel.
Good morning. May it please the court. My name is Paul Zuckerberg, and I represent the appellants. The appellants are civic organizations who are seeking to prevent the destruction of a historic plaza located at the intersection of 18th and Columbia Roads Northwest, which has served as the de facto town square for Adams Morgan for over 40 years. The appellants applied for a raise permit to demolish the plaza and unilaterally terminate the rights of the public to use the public space. That prompted a Superior Court action, a common law claim by the appellants that there is an easement by public dedication on the plaza portion of the parcel.
Your Honors, may it please the court, Mary Zinsner for Truist Bank. It's a privilege to be here before the Honorable Court today. During the 30 years that Truist has been the fee simple owner of this property, it's been a good neighbor, allowing organized usage of the property because Truist cares about the community it banks, as its predecessors did and as Perpetual did before them. The judgment record shows that there is no unequivocal clear intent to dedicate the property into perpetuity.
Ms. Zinsner, on that point, I know we focused quite a bit on the Owen letter, rightly so, and we've talked quite a lot about the later usage. But as I read through the appellant's reply and looking through the appendix, there's the Nahikan brief testimony, there's the Smith testimony, there's the Auerbach testimony. There's also, it wasn't recited in the trial court below, but there's also the FHLBB supervisory agent report, and really focusing on I think the focus both in prudential standing and the creation of the easement question, what happened in 1977 is the focus of the question of whether or not an easement was created. And is your testimony that is your argument that it's that the Owen letter coupled with the 3 depositions and the FHLBB supervisor's agent report are insufficient as a matter of law to create an issue of fact for the trier of fact to resolve?
Where do you find diversity? Columbia Road around 18th Street. You wanna stop? You know you should, 'cause this is a real good neighborhood.
The error that the trial court made, and I think it's come up clearly in the arguments, is at this stage of the proceeding, all of these inferences must be considered in the light most favorable to the non-moving party. And the inferences that whether or not the language is perfect or whether or not one witness's testimony is different on different occasions are all inferences which must be drawn in favor of the appellant at this stage. And the decisions as to intent and what the parties meant are classic jury questions.